Hello Year 12s and welcome to the second of 4 videos on key concepts in the Victorian criminal justice system. Outcome 1 of Unit 3 focuses on the Victorian criminal justice system, and the purpose of these 4 videos is to familiarise you with some of the key concepts that relate to that system. Many of these concepts have been covered in Year 11, so much of this should simply be revision, but it's important revision nonetheless. Having said this, there is some new information that we didn't cover in Year 11, and so you will need to take careful notes about this new information. There are 3 things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause, rewind, and fast forward functions. Pause if you need time to take notes. Rewind if you think you've missed any information and want to listen to it again. And fast forward if you already know the information and feel that you don't need to listen to it again. The final thing that you need to do is have your vocabulary sheet open in front of you so that you can include in it definitions of any important terms or definitions of words that you're unfamiliar with. When you have finished watching this video, please read the pages from the textbook that are referred to on the front of this slide, and then supplement your notes with any information from that reading that you think might be useful. All right, let's make a start then. This slide sets out our learning intention for this video. This learning intention is that you need to be able to describe the main features of the Victorian criminal justice system, including the role of the magistrate, judge, and jury in a criminal case. Write this learning intention down in your Cornell notes. On this slide, I have given you some examples of the different kinds of crimes. For these purposes, the crimes have been categorised as offences against the person, offences against property, offences against morality, offences against the legal system, and offences against the state. Offences against the person are offences that involve conduct that results in some form of personal injury. Examples are murder, manslaughter, assault, rape, and kidnapping. Offences against property are offences that involve conduct that results in damage to or loss of property. Examples are theft, vandalism, and robbery. Most crimes are either offences against the person or offences against property. Offences against morality are offences that are concerned with maintaining certain values in our society. So, for example, in Victoria, it is an offence to engage in incest, which is where 2 people who are closely related have a sexual relationship. Now, this is an offence against morality in the sense that it reflects society's view that even if the sexual relationship is consensual, such behaviour is detrimental to the proper functioning of the family unit and so should be a crime. Offences against the legal system are offences that relate to our responsibility to participate as responsible citizens in the administration of justice. One example of an offence against the legal system is perjury. Perjury is where a person comes to court as a witness and they swear that they will tell the truth. However, instead of telling the truth, they lie. That is, they lie under oath. Another offence against the legal system is failure to appear for jury service. If you are 18 or over and are an Australian citizen, then you must be included on the Victorian electoral roll, and anyone who is on the Victorian electoral roll can be called up to serve in a jury. If you do not attend for jury service when you are required to, then that is an offence. The final example I've given of an offence against the legal system is the offence of contempt of court. Contempt of court occurs where a person refuses to obey a court order. Finally, offences against the state are offences that involve conduct that undermines the system of government. The most obvious example of an offence against the state is treason. Treason occurs where a person tries to overthrow the government by force as opposed to voting against the government in a democratic election. As you know, in Australia, we have a national parliament, that is the Commonwealth Parliament, that makes laws for the whole of Australia, and separate state parliaments that each make laws for their particular state. The Commonwealth Parliament has made a number of laws about crimes such as drug importation, terrorism, and espionage or spying. These are laws that apply throughout Australia, and so, for example, drug importation is a crime whether it is committed in Victoria or in Western Australia. However, most crimes that you'll be familiar with are contained in laws that are passed by the state parliaments. These include murder, manslaughter, rape, kidnapping, burglary, and assault. Because each state parliament is able to make its own laws about what are crimes in their state, there may be different crimes in different states. While the most serious crimes are common across the states, there are a range of more minor crimes that differ from state to state. In addition, each state has its own police force and its own court system. As a result, there is not one single unified criminal justice system in Australia. The criminal justice system in Victoria consists of a set of processes and institutions that are used to investigate and determine criminal cases. There are a number of stages in our criminal justice system that a criminal case must pass through, and the rest of this video will look at these stages. The first stage is that an investigatory agency must investigate the crime and lay charges against the accused. Typically, the agency that investigates crimes and lays charges against an accused will be the police, but there are also other agencies in Victoria that do this. For example, WorkSafe Victoria is a Victorian government agency that investigates and lays charges for breaches of Victoria's workplace safety laws. The second stage is pre-trial procedures. Pre-trial procedures are procedures that apply to a person from the time they've been charged with an offence up until the time of their trial for that offence. There are three important pre-trial procedures that you need to be familiar with. These are bail, remand, and committal proceedings. Where the police suspect that a person has committed a summary offence or a less serious indictable offence, the police will generally charge the person on summons. This means that the accused will be given a notice to appear at the magistrate's court at a future date when court proceedings will be held in relation to the charge. However, where the police suspect that a person has committed an indictable offence, and in particular a more serious indictable offence, then the police are likely to arrest the person and take the person into custody for questioning. If the police charge the accused, then the accused will either be released on bail or held in custody, that is, held in prison on remand. Let's look first of all at bail. Bail is the release of a person who has been charged with an offence on the condition that they appear in court for their trial. Look down the left-hand side of your vocabulary sheet, find the term bail and write this definition in there. Highlight the words on the condition that and make sure that you use these words when you're defining the concept of bail. To begin with, the police will decide whether or not to release an accused on bail once the accused has been charged. However, if the police decide not to release the accused on bail, then the accused must be taken before a magistrate. It is then up to the magistrate to decide whether to agree with the police, in which case the magistrate will order that the accused is held on remand, or to disagree with the police, in which case the magistrate will release the accused on bail. Now, a fundamental principle of our criminal justice system is the presumption of innocence. This is that a person is presumed innocent unless or until they are proven guilty. At the time a person is charged with an offence, that person has not had a trial to determine whether or not they're guilty, and so at this stage they are entitled to be presumed innocent. This suggests that an accused person who has been charged with an offence should generally be released on bail rather than held on remand, because a person who is presumed to be innocent should not be locked up in jail. However, over the past 10 to 15 years, the Victorian Parliament has passed laws that restrict the circumstances in which accused people can be granted bail. This is a direct contradiction to the presumption of innocence. Another point to note about bail is that, in Victoria, most accused are released on bail without the need to pay any money to the state. This is very different from the United States, where bail is often closely associated with the idea that an accused can only be released from custody if money is paid to the state as security for that person appearing in court for their trial. However, in some cases, a person who is charged with an offence in Victoria will be granted bail on the condition that another person acts as the surety. That's S-U-R-E-T-Y. A surety is a person who agrees to pay money to the state if the accused absconds from bail, that is, if they skip bail and do not appear in court for their trial. This is a picture of one of Australia's most notorious drug kingpins. His name is Tony Mockbell. A number of years ago, he was charged with some very serious drug offences. However, a magistrate granted him bail on the condition that he surrendered his passport and that his sister-in-law acted as surety. As part of this arrangement, his sister-in-law agreed to use her $2 million house to guarantee that Mockbell would appear at his trial. And this meant that if he didn't appear at his trial, the state could take the house, sell it, and keep the $2 million. Well, Mockbell managed to get hold of a false passport, and he hightailed it out of Australia and went into hiding in Greece. He used this very effective disguise to avoid being recognised and arrested by the police in Greece for a number of years. An interesting feature of this case is that Mockbell's sister-in-law did not actually own the house that she put up as surety for her agreement to pay $2 million if Mockbell skipped bail. And this meant that the state could not actually sell that house and keep the $2 million, a rather embarrassing result for the state. You need to be very careful not to confuse bail with another important concept, which is the concept of parole. As I've said, bail is the release of a person from custody where that person has been charged with an offence but not yet had their trial. On the other hand, parole is the release of a person from prison where that person has been convicted of an offence and has served their non-parole period in prison. That is, the minimum period in jail that the judge who sentenced them said that person had to serve before they could be released from jail. Put another way, parole only applies to people who have been convicted of an offence, sentenced to jail for that offence, and served a period of time in jail. So parole is not a pre-trial procedure, and you must not confuse it with bail. Where a judge sentences a person to more than 2 years in jail, they are required to specify a non-parole period. And this is the time that the person must spend in jail before they can apply for parole. Once this period of time has expired, then the prisoner can apply to a government agency called the Parole Board for parole. And if the prisoner has been well behaved in jail, and if the Parole Board thinks that the prisoner will not be a danger to the community, then the Parole Board can release the prisoner from jail on parole. However, an offender who is granted parole has to comply with the conditions that the Parole Board imposes on them. These conditions apply for so long as the offender is still serving their sentence, albeit that they are serving their sentence in the community rather than in jail. These conditions may include things such as regularly reporting to their parole officer and not committing an offence while they're on parole. If the person does breach one of these conditions, then they can be sent back to jail, where they will serve out the remainder of their sentence behind bars. That's why we define parole as the conditional release of an offender serving a term of imprisonment. It allows the offender to serve the balance of their sentence in the community, provided that they comply with the conditions of their parole. Look down the left-hand side of your vocabulary sheets, find the word parole and write this definition in there. Please highlight the term conditional release and make sure that you use these words whenever you're defining the concept of parole. As I've said, if an accused who has been charged with an indictable offence is not released on bail, then they will instead be held on remand by order of a magistrate. Remand is the detention of a person who has been charged with an offence in custody, that is, in prison until their trial. Look down the left-hand side of your vocabulary sheets, find the term remand and write this definition in there. Please highlight in this definition the words in custody and use those words whenever you're defining the concept of remand. A magistrate will generally deny an accused bail and instead order that the accused is held on remand where the accused has been charged with a relatively serious offence, where the accused is a flight risk, that is, it's considered likely that they will skip bail and not turn up for their trial, or where there's a risk that the accused will interfere with witnesses in the case. The third type of pretrial procedures that you need to be familiar with are committal proceedings. Committal proceedings are pretrial procedures that are held in the magistrates' court for indictable offences that will go to trial in the county court or Supreme Court. Look down the left-hand side of your vocabulary sheets, find the term committal proceedings and write this definition in there. Please highlight the words pretrial, magistrates' court and indictable offences and use those words whenever you're defining the concept of committal proceedings. Some very significant things happen in committal proceedings. First, as we saw in the previous video, where the offence that the accused has been charged with is an indictable offence that can be heard and determined summarily, then the magistrate will decide whether that offence should be heard as a summary offence in the magistrates' court or as an indictable offence in the county court or trial division of the Supreme Court. The case can only be heard summarily in the magistrates' court if, first, the magistrate is satisfied that it is appropriate to determine the case summarily, and second, the accused consents to the case being determined summarily. The second important thing that happens in the committal proceedings is that the accused pleads either guilty or not guilty to the charges against them. If the accused pleads guilty to the indictable offence, then there is no trial, because the accused has pleaded guilty, and so the magistrate sends the accused straight to sentencing by a judge in the county court or the Supreme Court. The technical term for this is that the magistrate commits the accused for sentencing. The third important thing that happens in the committal proceedings happens during what is called the committal hearing. This is a hearing at which the magistrate determines whether the prosecution's evidence is of sufficient weight that a jury could, not would, but could, convict the accused at trial. In making this decision, the magistrate will take into account the prosecution's evidence, which is contained in a hand-up brief, that is, a compilation of the prosecution's evidence that includes transcripts of police interviews with the accused, prosecution witness statements, and exhibits such as photographs of the crime scene. If the accused wants to, the accused can, but does not have to, cross-examine the prosecution witnesses and present evidence, including by calling defence witnesses. The accused will do this where the accused wants to challenge the credibility or reliability of the prosecution evidence. The accused can also make submissions to the magistrate that challenge the strength of the prosecution case. Taking all of this into account, the magistrate must then decide whether the prosecution's evidence is of sufficient weight that a jury could convict the accused at trial. If the magistrate decides that the prosecution's evidence is of sufficient weight that a jury could convict the accused at trial, then the magistrate will send the accused for trial in the county court or the trial division of the Supreme Court. The technical term for this is that the magistrate commits the accused to stand trial. The magistrate will then need to decide whether to release the accused on bail or to order that the accused is to be held on remand until their trial. If the magistrate decides that the prosecution's evidence is not of sufficient weight that a jury could convict the accused at trial, then the magistrate will discharge the accused, and the accused is free to go. Importantly, a committal hearing is not a trial to determine whether the accused is guilty or not guilty. The purpose of the committal hearing is just to determine whether there is a sufficiently strong case against the accused that the accused should stand for trial for that offence in a higher court. So don't be confused about the fact that the criminal jurisdiction of the magistrates' court is to hear summary offences, but that committal hearings, which relate to indictable offences, are also held in the magistrates' court. Even though the committal hearing for an indictable offence is held in the magistrates' court, it is not a trial of the accused for that indictable offence. The accused can only be tried for that indictable offence in the county court or the trial division of the Supreme Court. The purpose of the hearing in the magistrates' court is simply for the magistrate to work out whether there is sufficient evidence against the accused that the accused should be sent for trial in the county court or the trial division of the Supreme Court. It's only at their trial in the county court or the trial division of the Supreme Court that it will be decided by a jury whether the accused is guilty or not guilty of the indictable offence that they've been charged with. Here's a picture of Cardinal George Pell outside the Melbourne Magistrates Court. In 2018, the police charged him with a number of historical child sex offences, and he went through a long committal hearing in the Melbourne Magistrates Court. Now, at this committal hearing in the Magistrates Court, the purpose was not to decide whether Cardinal Pell was guilty or not guilty of those offences. Instead, the purpose of that hearing was for the magistrate to decide whether there was sufficient evidence that a jury could convict Cardinal Pell of those offences at a trial in a higher court, in this case the county court. In Cardinal Pell's case, the magistrate decided that there was sufficient evidence, and at his subsequent trial in the county court, a jury did in fact find him guilty of child sex offences. However, that conviction was subsequently overturned by the High Court when Cardinal Pell appealed to the High Court against his conviction. This brings us to the third stage in the criminal justice system, which is determining whether or not an accused who pleads not guilty is in fact guilty or not guilty of the offences with which they've been charged. In this stage, a prosecuting agency, generally either the police or the Director of Public Prosecutions, prosecutes the accused in court for the offence or offences that the accused has been charged with. Where the crime is a summary offence, it will often be the police who prosecute the accused. Where the crime is an indictable offence, it will be the Director of Public Prosecutions who prosecutes the accused. The Director of Public Prosecutions is the head of a Victorian government prosecution agency called the Office of Public Prosecutions. The Office of Public Prosecutions consists of a number of lawyers who work for the government and who all prosecute criminal cases in the name of the Director of Public Prosecutions. So one party to a criminal case is the prosecution, which you can also refer to as the Crown or the State. The other party to a criminal case is the accused. This is because the prosecution, that is the Crown or the State, prosecutes the accused. In other words, there are two parties to a criminal case, the prosecution and the accused. The victim is not a party to a criminal case. Of course, the victim has an interest in the criminal case, but their only role in the criminal case will be as a witness, assuming it is not a case that involves the death of the victim. So never refer to the victim as prosecuting the accused or to the victim as having to prove that the accused is guilty. This is the role of the prosecution. Again, I emphasize that the only parties to a criminal case are the prosecution and the accused. The victim is not a party to a criminal case. The reason it is the state and not the victim who prosecutes an accused is that crimes are considered to be offences against not just the victim, but also against society as a whole. This is because crimes eat away at the fabric of society. For example, offences against the person threaten the safety of the community, and offences against property threaten the secure ownership of property. In addition, it's very important for society to see that the state is prepared to take action against people who commit crimes. Otherwise, there may be a breakdown of law and order as victims take the law into their own hands and seek justice by attacking the accused in some way. As you should already know from our discussion of summary and indictable offences in the previous video, where an accused pleads not guilty to a summary offence or to an indictable offence that is to be heard summarily, the case is heard in the magistrate's court where there is no jury. On the other hand, where an accused pleads not guilty to an indictable offence, the case is heard in the county court or the trial division of the Supreme Court where there is a jury. You must be careful not to confuse a magistrate and a judge. While they perform similar roles, and while both magistrates and judges hold legal qualifications, magistrates are only found in the magistrates' court and not in the county court or Supreme Court, and judges are only found in the county court and Supreme Court and not in the magistrates' court. Also, note that proceedings in the magistrates' court to determine whether an accused is guilty or not guilty are called hearings, but proceedings in the county court or the trial division of the Supreme Court to determine whether an accused is guilty or not guilty are called trials. So make sure that you do not confuse hearings and trials. Let's deal first of all with the trial of an accused for an indictable offence in the county court or trial division. In such a case, the judge and jury each have two roles, and it's very important not to confuse these roles. The first role of the judge is to direct the jury as to the law to be applied in the case. This makes sense because the judge is a legal expert, whereas the members of the jury are not. So, for example, in a murder case, the judge must direct the jury that before they can find the accused to be guilty of murder, they must be satisfied beyond reasonable doubt that firstly, the accused actually killed the victim, that is, that the accused committed the actus reus, and secondly, that when the accused killed the victim, the accused had a mens rea necessary for murder, such as that the accused intended to kill or cause really serious injury to the victim. The first role of the jury is to determine the facts. It is not for the judge to decide the facts. What this means is that it is entirely for the jury to decide what evidence they believe and what evidence they don't believe. So, for example, in our murder trial, it is for the jury to determine whether they believe that the accused actually killed the victim. It is for the jury to determine whether they believe that, when the accused killed the victim, the accused intended to kill or cause really serious injury to the victim. The second role of the jury is to decide the verdict. A verdict is the decision of the jury as to whether the accused is guilty or not guilty. Look down the left-hand side of your vocabulary sheets, find the word verdict and write this definition in there. Now, assuming that the jury finds the accused guilty, this brings us to the second role of the judge, and this is the role that the judge performs in determining the punishment for an accused who has been found guilty. This punishment could, for example, take the form of imprisonment, a community correction order, or a fine. We'll come back to sentencing in a moment, but let's add a bit more detail to the jury. In a criminal trial, the jury consists of 12 members. These 12 members are drawn at random from people who are included on the Victorian electoral roll. The Victorian electoral roll is a list of everyone in Victoria who is 18 years or over and who is an Australian citizen. Now, generally speaking, a jury verdict must be unanimous. A unanimous verdict is a verdict which is agreed to by all of the jurors, that is, by 12 out of the 12 jurors. Look down the left-hand side of your vocabulary sheets, find the term unanimous verdict, and write this definition of unanimous verdict in there. What this means, for example, is that if the accused is charged with burglary, then for the accused to be found guilty of burglary and convicted, 12 out of 12 jurors must agree that the accused is guilty. Alternatively, for the accused to be found not guilty of burglary, 12 out of 12 jurors must agree that the accused is not guilty of burglary. If the jury cannot reach a unanimous verdict after a number of hours, then the judge will generally accept a majority verdict. A majority verdict is a verdict agreed to by 11 out of 12 jurors. Look down the left-hand side of your vocabulary sheets, find the term majority verdict, and write in this definition of majority verdict. Again, taking our burglary case, the accused will be convicted of burglary if 11 out of 12 jurors agree that the accused is guilty of burglary. Conversely, the accused will be acquitted of burglary if 11 out of 12 jurors agree that the accused is not guilty of burglary. Even though we refer to this as a majority verdict, don't make the common mistake of assuming that a majority verdict means a verdict by more than half the jurors. It's a much higher threshold. For there to be a majority verdict, 11 out of 12 jurors have to agree on that verdict. Now, I've said that generally a majority verdict can be accepted where the jurors cannot reach a unanimous verdict. In fact, for some crimes, specifically murder, treason, and Commonwealth offences, a majority verdict cannot be accepted. So, for example, for an accused to be convicted of murder, they can only be convicted if there is a unanimous jury verdict that the accused is guilty. Obviously, it's going to be difficult for 12 out of 12 people, or even 11 out of 12 people, to agree on anything. If a jury can't reach either a unanimous or a majority verdict, then the jury is said to be a hung jury. A hung jury is a jury that cannot reach either a unanimous verdict or a majority verdict. Where the jury is a hung jury, then the accused is not found either guilty or not guilty. The jury simply can't make up its mind. Look down the left-hand side of your vocabulary sheets and find the term hung jury and write this definition in there. Because a hung jury has not found the accused to be guilty, the accused goes free. However, the jury has also not found the accused to be not guilty. Instead, the accused is in a kind of limbo because the jury has not decided that the accused is either guilty or not guilty. We only have a jury in a criminal trial held in the county court or the trial division of the Supreme Court. If the offence with which the accused has been charged is a summary offence, or if the offence with which the accused has been charged is an indictable offence, but that indictable offence is being heard and determined summarily, then the case is heard in the magistrate's court. As you know, there is no jury in the magistrate's court, so it is the magistrate who has to perform all of these four roles. It is the magistrate who determines the law, the magistrate who determines the facts, the magistrate who decides the verdict, that is, whether the accused is guilty or not, and the magistrate who determines the punishment for an accused who is found to be guilty. This brings us to the fourth and final stage in the criminal justice system, which is sentencing. Where an accused pleads guilty to an offence, or where an accused pleads not guilty but is found to be guilty at either a hearing in the magistrate's court or a trial in the county court or Supreme Court, then the accused faces a sentencing hearing. The sentencing hearing for a summary offence or for an indictable offence that is being heard summarily is held by a magistrate in the magistrate's court. The sentencing hearing for an indictable offence is held by a judge in the county court or the trial division of the Supreme Court. At a sentencing hearing, the prosecution and the accused make submissions to the magistrate or judge about the appropriate sanction and sentence to be imposed on the accused, or, as we can now call the accused because they have been convicted of the offence, the offender. If the offender has pleaded not guilty but has been found to be guilty, then the same magistrate or judge who conducted the hearing in the magistrate's court or the trial in the county court or Supreme Court will conduct the sentencing hearing. As part of the sentencing process, the magistrate or judge has to decide the appropriate sanction to impose on the accused, which will typically be imprisonment, a community correction order, or a fine. In deciding the appropriate sanction, the magistrate or judge will take into account the purposes of criminal sanctions, being punishment, community protection, specific deterrence, general deterrence, denunciation, and rehabilitation. The magistrate or judge will also need to decide the severity of the sentence. This entails the magistrate or judge taking into account 4 important sentencing factors, which are aggravating factors, the impact of the offence on the victim or victims, mitigating factors, and whether the accused has made an early guilty plea. Note that information about the impact of the offence on a victim is given through victim impact statements that are provided at the sentencing hearing, that is, after the hearing or trial at which an accused who pleads not guilty is actually found to be guilty. A victim impact statement is not evidence and is not used in deciding whether the accused is guilty or not guilty. Its sole purpose is for use by the magistrate or judge in determining the severity of the sentence that is to be imposed on the accused. We looked at sanctions and their purposes, as well as sentencing factors, in Year 11, and we'll revisit these in more detail later on in Outcome 3. Now it's time to test some of the knowledge that you've hopefully learned from this video and the previous video. On this slide, I've set out a case scenario which contains 3 errors. I want you to see if you can identify each of the errors, explain why each of them is an error, and provide the correct information. Under this case scenario, Liam has been charged with armed robbery and his case was heard in the magistrate's court. At the trial, Liam was found guilty of armed robbery because 4 of the 6 members of the jury were satisfied that he had committed the armed robbery. The jury then sentenced him to 10 years in jail. So, pause this video while you try to identify each of the 3 errors, explain why it is an error, and provide the correct information. Alright, let's see how you've gone. The first error is that Liam has been charged with armed robbery, but his case is being heard in the magistrate's court. Armed robbery is an indictable offence, and therefore his case should be heard not in the magistrate's court, but in either the county court or the Supreme Court. The second error is that Liam has been found guilty of armed robbery because 4 of the 6 members of the jury are satisfied that he committed the armed robbery. The first error here is that in a criminal case the jury has 12 members, not 6 members. The second error is that for Liam to be found guilty of armed robbery, either the jury has to come to a unanimous verdict, which means 12 out of 12 members have to agree that Liam is guilty of armed robbery, or else, if they can't reach a unanimous verdict, then they have to come to a majority verdict, which means that 11 out of 12 jury members have to agree that Liam is guilty of armed robbery. And here's the third and final error. The jury sentenced Liam to 10 years in jail. It is not the role of the jury to sentence an accused who is found guilty to a punishment. That is the role of the judge. Hopefully, you've picked up all of these errors. Well, that now brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to describe the main features of the Victorian criminal justice system, including the role of the magistrate, judge, and jury in a criminal case. Don't forget that you now have to read the pages of the textbook referred to on the first slide and supplement your notes with any additional information from this reading that you think would be useful. Thank you very much for your attention.